हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
Now we fundamentally agree with all these points, and thank you so much for actually putting that point in public domain. And what we have decided to do is that we will follow the case material the way it is provided by the Delhi University. So, for example, if there are certain writings which are mentioned in the case material, fundamentally we will use those. We would use those writings to explain other related writings. Another point which was raised in the last lecture. Now, in so doing, for today, what we have proposed, and this is something which we are going to continue for the next two lectures as well, that we will pick up Star's writing, which is already part of or which has already been sent to your Google Classroom. It is uploaded there by Anumeha. Now, Star fundamentally talks about Hart's idea of law and how morality pictures in Hart's idea of law. So maybe we will use this paper to revisit some of the points which we have already covered. Maybe some of the points which are so central that even if basic, that we need to understand them in detail. So maybe what we propose to do is to pick up every paper in different sections rather than picking up one paper as a whole, and picking up these papers in section and dealing with it in different lectures. Now, at least for today, what I propose to do, and since I intend to talk about the introductory part of Star's paper, what I propose to do is to introduce the various debates about law and morality, as to what is it that we are really talking about when we are focusing on law and morality. What are the larger debates, and why are scholars divided in different camps when it comes to the interface between law and morality? That's what my intention is. Now, before this lecture, in fact, till yesterday, I thought of maybe introducing this idea through Star's paper, but then I thought that maybe some domestic case laws might appeal you more, and maybe might be more interesting. Might be more interesting in terms of approaching the question of interface between law and morality. So what I did was to go to some domestic case laws decided by Supreme Court and High Court and see whether they have met certain statements about interface between law and morality or not. So that we will start our discussion with that. Anumeya, can we have the next slide if that's all right? Yeah, fine. So the agenda for today's discussion is twofold. Fundamentally, we are going to look into two important questions today. The first question which we are going to look at today is that how does law and morality interact with each other, and what are the different approaches with regard to such interactions. We will not get into, for example, how Hart would talk about, or Hart would conceptually talk about the interface between law and morality. Today we will just try to introduce those ideas of interface between law and morality and revisit some of the arguments which we have covered in the past lecture. And the second thing which we will talk about today is the aspect which is often known as construction and criticism. This is that when scholars try to approach the question of law and morality, how is it that they approach that question? Meaning thereby that whether they merely justify the separation model that in law and morality are different, or while justifying the separation model, they also, for instance, critique the other model which talks about the fact that no, law and morality are one and the same and not separate. So maybe we will try to see as to how the criticism of different approaches goes hand in hand with the construction of argument by one camp. And we are going to explain this point further with the help of natural law scholars. Yes. Now, what I propose to do is to pick up at least three different statements from, say, two judgments. I had few more judgments to talk about, but then I thought of confining the class discussion to these two judgments and the statements emerging out of these two judgments. Now, first is a case decided by, thank you so much. First is a case decided by Supreme Court of India. And Supreme Court of India decided this case in 2010, it seems. The name of the case is there in front of you. That is Ramchandra Bhagat versus State of Jharkhand. There were two judges in this case. One was Justice Katju and the other was Justice Gyansudha Mishra. Now, the facts of the case are very simple and perhaps not too important for our discussion, but let's at least have a basic idea about the facts of the case. That the appellant, that is Ramchandra Bhagat, it seems that he was living with the complainant, a woman, for 9 years, and they had 2 children. Now, they never got married, in fact. Now, after 9 years, it seems that appellant refused to marry her. Now, the complaint was filed under section 493 of Indian Penal Code. Now, in the complaint, it was said that Ramchandra Bhagat basically cohabited with the women by inducing a belief of lawful marriage, and therefore it violates or for example, he has committed a crime under section 493 of Indian Penal Code. Now, the matter came before the court. Now, irrespective of the larger analysis of section 493 and whether the facts of this case would fit under section 493, of course, Karju was of the view that no, it would not fit in within the purview of section 493. But in so doing, he made 2 statements which are important for our discussion, and we are going to talk about these 2 statements, in fact. Now, Karju said that yes, the accused, which is Ramchandra Bhagat, he has not behaved like a gentleman. He has behaved in an irrational manner and has not behaved as a decent person, and he should have married the complainant after living with her for 9 years and then also having 2 children out of that relationship. But then he goes on to make another interesting statement in paragraph 2. However, and this was when he was convinced that this entire issue is not covered by section 493. He says that there is a difference between law and morality. And he further says that there are many things which are regarded by society as immoral, but which may not be legal. If we say something is illegal, then we must point to some specific section of IPC or some other statute which has been violated. Merely saying that person has done something improper will not necessarily make the act illegal. This is a very interesting statement. He says that, there might be an act, there might be a particular conduct on part of one person, but that does not necessarily imply that a law has been violated. So, an immoral act, and Karju seems to be indicating that yes, the way person behaved was immoral. That was an indecent act on part of the person. But then he immediately qualifies that understanding with this remark, saying that there's a difference between law and morality, and there are different boxes, and these boxes are in the form of sections of Indian Penal Code. If you really want to get into a legal analysis, then you will have to put the circumstances in one of the boxes which IPC seems to have created. Otherwise, merely saying that something is immoral does not mean that the same thing is illegal. Now, this is one part of the judgment. Now, in relation to the same issue, there was this another judge, Justice Gyansudha Mishra. Now, she made a very interesting remark. Of course, she disagreed with Justice Karju at the end, and she makes this remark in the first paragraph itself. She says that while there is no difficulty in accepting the position that law and morality might stand on different footings or different stands, they are inextricably linked in my perception. Now, she acknowledges the broader part that yes, there might be a difference between the position where law stands and the position where morality stands. But mere fact that there is a difference in terms of their standing, that does not mean that they are not related to each other. So they are related to each other. Maybe we can have a debate about the degree of that relationship, but at least what comes out of this statement is that they are related to each other in fundamental ways. These are 2 statements. Maybe at least the way I could read these 2 statements, they seem to be different from each other. Now we go to another case. This is another very interesting case. And this is the last case which we take up for discussion today from an Indian court trial. This case is Industrial Credit and Development Syndicate Limited versus Khanderao Ramaro Sivalkar. This is a case decided by Bombay High Court in 1997. The matter in this case related to execution of a decree. So the decree was to be executed, but for some reason, one of the parties, he filed multiple petitions before the court, and because of that, there was a stay put through the orders of the court, and stay put in relation to the execution of the decree. Then the matter was before the court. Of course, court held that the execution application is barred by the law of limitation in terms of how the decree was to be executed within a particular period of time, but it was not. But court made this interesting remark, and this was Justice R. Kocher. Now, this is what he says in paragraph 11. He says that I am not able to divorce law from morality. According to me, law is based on moral values of the society. Law is not devoid of morals. No rule can be used to defeat moral values. Of course, I've removed some of the issues in between, mainly to make it more convenient for a class discussion. Now, we have three models here. One is Justice Karju's view in the last case, which we studied from state of Jharkhand. Ramchandra Bhagat versus State of Jharkhand, 2010 Supreme Court. Then we have Justice Gyan Sudha Mishra's opinion, and then we have Justice Kocher's opinion from Bombay High Court. Now, if these three statements are put before you, do you see any difference between these three statements? This is from Indian courts. It's not something which is taken from Hartz's paper or any paper for that matter. It's pure. I went to Manupatra. I tried looking at case where some discussion on law and morality has happened, and especially in relation to not justice and morality, but maybe how morality and law intersect with each other. And these are the statements emerging from there. Now, I would just like to pose this question for a class discussion. Do you see any difference between these three? And if at all you see a difference, what is the difference we are talking about? How is it that these three statements, these three remarks differ from each other? Yeah, anyone? Let's start with a more fundamental question. Are they different?
Yes, sir. In my opinion, they are different because if we look at the first judgment, there is this acknowledgement that law and morality, they are established on different grounds, and subsequently they might interact with each other. But as far as the second judgment is concerned, it is outrightly saying that law is derived from morality, which leaves no scope for any sort of difference or any sort of separate existence.
Okay, wonderful. This is a good thing. Maybe we can take one argument out of it, that there seems to be a difference between the first judgment and the second judgment. That is what you want to say, Vikramaditya?
Yes.
Okay, fine. Anyone else?
Sir?
Yes, please.
Sir, in the Justice Karju opinion is that we should not merge law and morality at the same time. Law is different, morality is different. So every moral act may not be illegal, but every illegal act shall be immoral. And in the second judgment, I observed that the law and morality is not the different thing. They are derived from the same origin. So the law should be always moral. That's my observation is correct, sir.
Thank you, Anjali. That's very helpful, in fact. So, just like Vikramaditya, you also seem to locate a difference between the first judgment and the second judgment, meaning thereby that the first judgment is Ramchandra Bhagat versus State of Jharkhand, and the second judgment, that is Industrial Credit and Development Syndicate Limited. So you see a difference between these two judgments, right? Anyone else? Well, these are two very helpful observations, both Vikramaditya and Anjali.
Good evening,
Third observation.
Hello.
Yes, Prakhar, please.
So, in the first judgment, Justice Kharki says that both morality and legality are different things, and the person has not committed any illegal act, because illegal act is one which is supported by, which is made illegal by IPC. So he has done nothing wrong according to IPC, and therefore the act is not illegal.
Yes.
In the same judgment, Justice Gyansudha Mishra says that that both morality and legality are interlinked, and that is, it cannot be separated, I think, according to her. In the next judgment, says that both are interlinked and law cannot be devoid of morality. It has to be based on morality. And if law is not based on morality, it's not a law.
Okay. It's wonderful. Now we have the initial statement by Vikramaditya and Anjali. They wonderfully summed up the difference between the first judgment and the second judgment. Say that, for example, when we go to the remark of Justice Kharki, he seems to be talking about strict separation between law and morality, and they both are right when they say that. Now then they jump to the second judgment and they say that Justice Kochar, however, seems to imply the opposite, where they say that no, law and morality are related to each other. So what is immoral would also be considered as illegal. Now, going by these two remarks, which is wonderfully framed remarks by Vikramaditya and Anjali, there seems to be two views emerging out of what we just covered. Now, Prakhar, however, seems to see three different views coming out of these two judges. Of course, he locates Gyansudha Mishra differently than Karju, where Gyansudha Mishra says that I have no difficulty in accepting Karju to a large extent. And to a large extent means that yes, law and morality, they stand on different footing. They have different standing. At the same time, there is some connection between the two. Of course, she has not talked about what that connection is, what that connection might be. That is open to larger debate, something which we are going to debate very forcefully in the next few weeks. But at least what emerges out of Prakhar's opinion is that there is also a third viewpoint. And the third viewpoint says that law and morality are independent of each other in terms of how they stand, but that does not mean that they don't intersect with each other. They are not linked with each other. These are the three viewpoints which Prakhar seems to have pointed out. Any other viewpoint, which of course covers almost, but I would like to hear from others too. What is their opinion in this regard? But thank you so much for all these wonderful statements, by the way. If you can't speak the speak, you can also type it in the chat box. Yes, sorry, someone is speaking, it seems.
Yes, sir. Hello, sir. Good evening, sir.
Yes.
Sir, I find these, we have three judges who has been speaking about the distinction between law and morality.
Yeah.
So I find that the second judge seems to be making a compromise between the first and second. But it is very difficult to understand, like in order to make an assertion whether law and morality are different or the same, first we need to start our inquiry into the subject of the origin of law itself. When we understand where the law has come up and what is the source of law, then we can make a very good judgment regarding the difference between law and morality. In fact, like 1 month before, I wrote an article on secularism. In that, I made one point regarding especially this positivists. If you give me permission, I would read that argument which I wrote few months back.
Yes, sure, please go ahead.
So I started asking a question, like this is the question which I wanted to ask myself while I was writing that paper. So I just made this at the point of time. When we are trying to understand law, should we take the help of other allied subjects also while trying to interpret the law? This is the first question which I want to ask myself. So to put it more clearly, if the law of the land has to be seen without the interference of any other allied subjects, let us assume it is so, then all the laws has to be the same of all countries in all the time, which is not the case in reality, from which we can deduce the fact that laws which are codified in a particular country at a certain point of time derives its form from the content of other areas of epistemology. So I just wanted to ask, isn't it an illusion of positivists who argue that we should look law as it is and not as out to be? For the reason because what we see as it is not what actually it is, because it derives it from other kinds of subjects. So this is what I wanted to ask. So to put it in Adi Shankaracharya's terminology, we see the form of clay in different forms, but the inner content is same. So by this means, I just wanted to know, so what we talk about law, isn't it the basis of morality that we got its origin into law or not? Like, is it really possible for us to distinguish this is law and this is not law when it comes to the subject of morality?
Okay, thank you so much, Rakesh. These are wonderful remarks. Again, I mean, we will get into, and the question which you are asking, in fact, that's the question we are going to talk, discuss, disagree, and of course, fight violently about throughout the semester. And I will try to reflect on that question with the help of the remarks made by your friends. But one point which you made in relation to the examples which we have taken, so that the discussion can move ahead, is that how the second remark of Gyan Sudha Mishra seems to project a compromise between the first and the second one. That's a very, very interesting remark to make. So Rakesh seems to have gone one step ahead, and he argues that yes, there is a difference, but there is something peculiar about the second remark. And the second remark is that it is a bridge between the first and the second one. That it says that yes, these two are different things. These two are different things. At the same time, they interface with each other. Of course, the degree of such interface is something which we will see, that whether to what extent Hart agrees to it, or to what extent Fuller tries to project that degree. Now, these are the four statements which has come out of the class discussion today. To put it in simple words, and maybe to summarize what your friends already said, Vikramaditya and Anjali seems to identify the broader contradiction between, say, law and morality being one and law and morality not being one. Prakhar went one step ahead and he says that, there are three statements here. One is that law and morality are different. Law and morality are one. And the third statement is that, no, law and morality might be different in fundamental sense, but there is some connection between these two. And Rakesh further reflected on it by saying that the third statement, that law and morality might be different, but there is some link, some connection between these two things, is nothing but a compromise between the first and the second. Therefore, what emerges out of this entire discussion, and that too from the class discussion as a whole, are the three different viewpoints. Anumeya, can we have the next slide? Yeah, the next one. Yeah. What emerges out of the class discussion, the three different approaches to study the relationship between law and morality. The first is that law and morality are completely autonomous. To put it in simple words, what is immoral is not necessarily illegal. The second remark would be that morality intersects with legal system at different points. So there is some connection between law and morality, though they might be different, but at different points, at vital points, there might be some connection. And the third remark is law and morality are one. To put it in simpler words, what is immoral is necessarily illegal. Just remove that not, that shouldn't have been there. Yeah. Okay, that's it. Yeah, so the last one is that what is immoral is basically illegal. Now, we try to box different streams of thought. Yeah, thank you. Yeah. Now, we try to box different streams of thought in these camps being represented by first, second, and third. So we might say that, okay, you know what, positivist, maybe a radical positivist would belong to the first group. A natural law scholar would belong to third group. Maybe a positivist who tries to rationalize, who is able to see the relationship between, however peripheral that relationship might be, between law and morality would be fixed or can be placed in the second group. Now that is how we try to box different philosophers. Now that you are introduced to this basic idea, let me go back to the lecture we were having last week and introduce this case to the entire class again. And the case is grudge informers case. Now let me explain the facts of the case again, and then I would like the class to reflect on that particular case. In the light of what we just saw, if you were the judge in that particular case, that is grudge informers case, how would you decide that particular case? That's the issue. Let me very briefly, and those of you who were either not part of the class or actually forgot what the case was about, maybe let me put the facts of the case in very few sentences, and then we can have a discussion on that. This case is about a woman. Now, it seems that in 1944, this woman was very unhappy with her husband, and when the husband came home he was working with the army, and when he was on leave from the army, he came home and made certain remarks about, say, Hitler. Now, under the law, under a 1934 Nazi law, making remarks against Hitler, Third Reich, or the German army was prohibited. It was a criminal act. Now, what the wife does was that she goes to the authority and complains that, husband has made certain remarks which is against this specific law. The husband was tried. He was then punished for making such remarks against Hitler, and then finally sentenced to death. But he was not executed. He was sent to the front to fight war for Germany. Of course, when Nazi Germany lost the war, these informers were being tried. Now the matter was before the court. And when the matter came before the court, wife made a very simple argument. Wife said that, her action was justified by the Nazi law. Nazi law prohibited such statements, that you cannot basically make statement against the Third Reich or the German army, or, for example, Hitler. And the husband did that. And therefore, the action was not violative of law. The argument from the other side was that this law is an illegal law because it is an immoral. Since the law itself is immoral, therefore, there's no legal validity to this law. This law cannot be considered as a law itself, to put it in more simple words. Now, just imagine that you are a judge and you are deciding this particular matter. And in the light of what we just saw, the three larger debates emerging out of distinction between law and morality, how would you approach this issue? How would you decide this issue if you are a judge? Anyone? If you want any clarity on the facts of the case, we can do it again. I can explain the facts of the case again. Maybe I've tried to, not to modify it, but try to bring it down to very basic so that it's easier for us to have a discussion on. Nobody wants to be a judge. If you can't speak, you can also type your response in the chat box. Anyone?
Sir?
Yes, please.
Sir, as we discussed in this class, that we are basically dealing with the relation between law and morality. So in the case that you just have mentioned the facts, regarding this, I think law and morality both govern our actions as what should we do and what should not we have to do. But as a judge, when we are dealing with the cases, our prime question is what should be the basis of giving the punishment? And according to me, it should be the law and not the morality for giving the punishment. As morality is basically from the society, and in Indian society or in any other society, there can be different cultures, different opinions, which may lead to ambiguous relations and which may constrain the opinions of the judges. So law should be little bit different from the morality, in my opinion, sir.
So, Yogesh, according to you, the women should not be punished.
Yes, sir. Yes.
All right, fine. So, this two very interesting statements from Yogesh. One is that law which should govern the conduct or should regulate the society and not morality. The fundamental reason being because morality is often unclear. So, what is morality? We are never sure about as to whether a particular notion is the correct notion of morality. So, fundamentally, when it comes to the regulation of society, it should be law per se and not morality. Therefore, women, in the grudge informer's case, should not be punished because her action was very much in line with the 1934 Nazi law. Any other viewpoint? Any viewpoint disagreeing with Yogesh?
Sir?
Yes, please.
So to counter that argument, he made that morality is different for different jurisdictions, let us say, and that is the reason why you should stick on to the law. So this was the primary argument of Yogesh. So I just wanted to make a comment that if the morality is different from different jurisdictions, why don't we apply the morality of that particular jurisdiction? For example, if you are trying a person in India, apply the morality of India and try to interpret the law. Whereas in this particular case, for example, let us say, I think it is the International Court of Justice. Is it the one which is prosecuting that woman? If it is so, then apply
it is international law. Yeah, Rakesh, it is not International Court of Justice. This is a court in Western Germany. And this court and the matter was before that court. So it is not an international court that we are concerned with.
Fine, sir. What I want to tell is, for example, if a person has been trialing in national court, let us say, apply the morality of that land. So I think it would be more better, right? But some people might say that we don't have any kind of morality in international law kind of thing. But there are certain categorical imperatives which was propounded by people like Immanuel Kant. So we can apply those kind of morality at international jurisdictions, whereas at national jurisdictions we can apply the morality of one's nation.
Okay. Now Rakesh's statement is that fine, there might not be a universal morality. We can debate about it whether there can be a universal morality or cannot be a universal morality. What he seems to be saying is that when the matter is before a municipal legal system, apply the morality of that legal system. So, for example, if the matter is before an Indian court, there must be some moral principle within Indian legal system which should be identified and applied in a case. But of course, disagreeing with Yogesh, what he seems to be saying is that the women should be punished by applying the morality of, say, whatever morality prevailed in Germany at that point of time. Isn't that right, Rakesh? That would be your conclusion.
Yes, sir.
Yeah, fine. The women should be punished by applying, say, even a municipal morality, if not an international morality. Yes, fine. Wonderful. Any third viewpoint? There is something in the chat. Yes, please. Yeah, sorry.
But this morality has changed with the change of the government or the ruling party, because earlier the law said that it was allowed and that is what she did. But later you are talking about morality, which maybe after end of that regime, presently it is there. So it's not only about morality changes with respect to place, but also with respect to time. And who will be deciding what is moral? So I feel morality can be used to make law, interpret law, but if somebody has done something which was legal, it should not be punished saying that it was not immoral, because she did whatever was mentioned in law. She was sticking to the law. She did what was legal. So maybe you can interpret the particular law with morality and say that on a later stage this will be law, the law can be changed, and further after that particular time it may become a law. But till then, when the lady did that act, it was not legal, and so punishing her on that vague understanding of morality can't be justified.
All right. This is very interesting. Now, Rakesh seems to have followed or at least countered Yogesh's opinion. Now, Prakhar seems to have developed over Rakesh's opinion, and he says that fine. I mean, Rakesh seems to be pointing out towards certain territorial limitation which morality might have. He said that morality is not just defined by territory, but also morality is defined by temporal factors. So morality at one point of time might not continue for say 100 200 years, or even for example 10-12 years. So just because there was a particular form of morality during Nazi Germany, if at all there was, that might not have prevailed in a post-Nazi Nazi regime. And his conclusion therefore is that we should not box morality, or we should not find significance of morality only in territorial sense. And morality should not be used to say punish the conduct of women who was justified in doing what she did following the 1934 Nazi law, and therefore the women should go unpunished. Is that what you want to say, Prakhar?
Yes, sir.
Thank you. Now there is something, Akansh, I just saw your text. I'm very sorry. I think wife seems to have performed an immoral act, but legally she can't be held guilty according to law. I think she was protected by the law at the time. There are many moral immorality acts that are prejudiced to our experiences, but the act of punishment comes from formation of rule of law. Okay, fine. So Akanksha, are you trying to conclude that the wife should not be punished and the law should have been followed rather than moral considerations? All right, fine. So it looks like there is a good chunk of. I mean, this is most of the responses which we have received. There seems to be an indication that wife should not have been punished. Now, this is not because there is something bad about morality which has been spoken from your side, but to say that fine, morality might be an important consideration, but there are far more significant dangers of invoking morality. And the connection in all the responses which I saw, where you said that no, wife should not be punished, is that morality is a very indeterminate idea. You cannot box morality in territorial sense. You cannot box morality even in temporal sense, that for all the times morality would be the same. There are different kinds of morality which differs according to time, place, and context. And therefore, morality is an indeterminate idea, something which cannot be determined concretely. And therefore, a fundamental argument which is being made is that wife should not have been punished. Fine. Now, why did we get into this exercise? Okay, ready. If the argument is morality changes with respect to time, isn't it a fact that law also changes with time and place? Yes, it is the case. It might be the case. Any responses to this, by the way? The change in morality and law. Morality changes, but so does law. So what is great about law, that the change in law should be accommodated and should be seen as a valid exercise, necessitating its application. But the same cannot be said about morality. That's the argument which I got from Rakesh's observation. Any responses to this? Because some of the arguments which were made by the class seems to be reflecting on this point.
Sir?
Yes, please.
Sir, in my opinion, the ultimate aim is to achieve justice, because that is what we can call as the ends.
Yeah.
If we take either law or morality as the means. Therefore, if we apply morality while adjudicating, morality is in a sense quite subjective. So that might lead to achieving injustice. So, and law is more objective when compared to morality. Therefore, I am of the opinion that law should prevail over morality, although both changes according to time.
Okay, wonderful. That's a very interesting statement by Dhruv, and also seems to be giving some response to Rakesh's observation that fine, I mean, morality might also change, the law might also change, but when there is a change in law, there is a bit of a certainty as to what has been changed. It is more identifiable in its application, in its scope, and its content. And that's one of the reasons,
also, sir, if I
Yes, please. Yeah, please go ahead.
So if I may just add to what has just been said about justice, I believe that in the sense that if the new law reflects an evolved or reformed version of morality, and if we seek to apply that to past crimes, as in past acts which are considered crimes as of today. So I believe what would happen is that we would set a dangerous precedent. Because the question would be, where would it end? And I think it will just descend into a form of witch hunt for me. Because again, like what Dhruva just said about justice, I think this would promote a sentiment of retributive justice. That, for instance, slavery laws, so all the previous slave masters might be prosecuted for acts which, according to the current law, are illegal, but at that time they were legal. So they would have no defense left to make their own case that they were just following a system. And of course, that might be immoral at the time, but then in terms of following the letter of the law, if we override that sort of morality and impose a fresh morality, then again, as you said, morality is vague, so we might just extend the new moral argument to everything and anything. That's what I think. So there should not be any retrospective application of the new law.
Oh, I'm so sorry. I'm extremely sorry. I was still on mute and then I kept on speaking. I'm very sorry. Yeah. So what I was trying to say is that why did we get into this exercise of identifying, say, law and morality? Can you hear me? Yes.
Yes, sir.
Yeah, okay. So why did we get into this exercise of, say, identifying the relationship between law and morality? The fundamental reason was to see different arguments which may be identified or which may be advanced to decide, say, life cases. So the question of law and morality is not just a theoretical discussion which we are having. It has something to do with many judgments which are decided by, or many disputes which are before the courts in India and elsewhere. Also, the second reason as to why we got into this exercise was to identify that it is not an easy task to say that law and morality are either connected or not connected. Among, say, 15, 20 of us who are here, it's impossible for us to come to a final conclusion that whether they are related to each other or whether they are not related to each other. If at all they are related to each other, what is that relationship which we intend to see? Now, these are questions which are open to debate and discussion. And that is precisely what we are going to do over the next 2 or 3 lectures. So in the next 2 or 3 lectures, our intention is basically to get into all these larger debates one by one. We have already tried to touch on Hartz's idea of law and morality. Maybe we thought of explaining it differently this time with the help of, say, Starr's paper, which is part of your case material. So we follow Starr's paper only to see as to how this connection between law and morality is placed. Now, let me move forward. Now, in moving forward...
Sir?
Yes, Anjali, speak. Yeah.
Yes, sir. My friends putting the argument that the morality is different from the nation to nation, but my point of view is that some morality is universal in nature. So who will decide that what is moral, what is immoral? I think we should follow the natural law that we ourselves feel that when we do something wrong, that it is not correct. So that we inherently feel that something is wrong. I think we all are human universally. So that should some value as a universal in nature. So I think that morality should not be stick to one country to another. So I think, sir, if the husband and wife are talking between them privately, they should not be punished in the court as said that statement was against the government or I think the wife should not be punished.
All right, thank you, Anjali. And the basis of your conclusion lies in some form of morality, isn't it? Which is, of course,
Yes,
I don't know. You also tried to speak about international, global morality and national morality. All right, fine. Yeah, Shahbaz, that heart doesn't talk about change in morality from time to time. Yes, Shahbaz, we are going to come to all those aspects one by one. So no part of discussion today reflects on Hart's idea of change in morality from time to time. What we are trying to do is to maybe prepare a background or maybe stage for different scholars to come in, not just HLA Hart, but even different scholars to come in and see that how they engage with the question of law and morality. We are also going to study Fuller for that matter and see how their engagement with law and morality has actually worked out. Now, with this brief introduction, let me at least point out two important aspects which Starr seems to be making in the initial part of his paper, and then I will be done for today. The first part, and something which I'm going to reflect on very briefly, is and the way I read it is about making an argument and then offering a criticism. And at least 2 or 3 paragraphs, he sums up tacitly but beautifully. He says that there could be 2 ways of dealing with a problem. If, for example, there is a particular view that law and morality are one and the same thing, meaning thereby that what is immoral is also illegal. Now, one way of dealing with such kind of articulation could be that you rationalize this thought. You present your own arguments as to why you believe that there is no distinction between, say, morality and law. One is the reflection of other. Now, many natural law scholars would get into this exercise and they fundamentally say that there is a necessary relationship between law and morality, and when there is a conflict between, say, natural law and human-made law, natural law must prevail. Now, they would further go to the extent of saying that all law must be morally justified if it is to be legitimately called law at all. Now, these would be some of the fundamental explanation points for natural law scholars broadly to say that, law and morality, there is a necessary relationship between law and morality. One reflects the other, one should reflect the other. This is just one way of engaging with a question. Now, Starr seems to point out that there is another way of engaging with a question, and something which we often focus on. And the second way of engaging with that question is that when there are 2 different viewpoints in relation to the same question. So, if there is just one viewpoint that law and morality are a reflection of each other, or all law should be moral, then you keep on explaining, keep on rationalizing that point and say that why do you believe that every law has to be moral in its character. But if there is an opposite viewpoint saying that no, law need not be moral, then merely advancing an argument does not suffice. Then you also need to provide a critique of the other argument. So, for example, if there's an argument that, say, traffic police is important to regulate, is important to regulate the traffic on Delhi roads. Now, this is one argument. Now, you can give 10 different arguments for that as to why, for example, traffic police is important. Now, there's another argument that no, instead of traffic police, we must have robots to regulate individuals. Now, there could be an argument that robots are objective, traffic police. Issue of corruption, there's issue of subjectivity and all those things, and the robots are more objective. So, for the first argument that traffic police is important, merely rationalizing that particular point will not suffice. A counter argument in relation to the proposal that robots should replace traffic police also has to be produced. This is precisely what Starr also seems to indicate very tacitly when he says that there must be certain fundamental things about natural laws. At the same time, natural law does not stop at explaining its fundamental elements. It goes one step ahead, and in going one step ahead, it critiques positivism. It says that the distinction between law and morality, as proposed by positivism, does not stand on fair ground. And in so doing, they also strengthen their argument. So criticism also leads to construction. At least the way my reading goes, that seems to be a very important argument coming out of it. That by critiquing positivism, that as to how, for example, positivists do not take into account any form of knowledge apart from knowledge which is based on real and material experience. And positivism discards all other forms of knowledge. Similarly, positivism shows that law is a product of power. So positivist idea of law shows fidelity towards power in terms of how it is seen as command of a sovereign. Now, further they go on to argue that, for example, law is just demonstrative of one side of projection of authority, that is from the commander to the commanded, rather than, say, a tacit cooperation of the lawgiver and the law follower. Say that all these elements are missing from the idea of positivism, and it happens because they make a distinction between law and morality. Now, this is one argument which seems to be coming out of the Stars paper, that it's not just about the articulation of a given idea which matters when we are studying the relationship between law and morality. Rather, what also matters is the kind of critique which has been provided in relation to a counter argument. So all these two arguments will go hand in hand. Now, just look at Hartz's paper. Hartz tries to defend this separation model of law and morality by critiquing those that this separability thesis is not maintainable. At the same time, Hart also develops his own idea of positivism, and he agrees with Austin and Bentham on certain points, and then he also disagrees with Austin and Bentham on certain points. So how while engaging with the critiques, Hart develops his own idea of positivism in doing that exercise. That's one argument which is emerging out of it. The last argument which I would like to speak on, at least for a minute, is that there is often a tendency on our part to label scholars, and this is something which is quite interesting, and something which we don't talk about often, is that we often put scholars as a positivist scholar or say a natural law scholar, or for example a scholar who believes in some other categories, or maybe who believes in the fundamentals of some other school. But Starr seems to say that there is a difference between all these criteria. We cannot mix one with the other. Even within positivism, there is a difference of opinion among different scholars. In fact, at one point of time, he goes to the extent of saying that the difference of opinion within natural law scholarship and positivist law scholarship seems to be far more intense than how the difference between, or the disagreements between the scholarship of natural law scholars and positive law scholars are placed. So mere fact that a particular label has been given to one single scholar, that he is a positivist, does not mean that he agrees with the positivist elements propounded by other scholars belonging to the same camp. To give an example, Hart might be considered as a positivist, but that does not ipso facto means that Hart agrees with all the arguments which Austin has made, another positivist. Just because Austin's idea of positive law has 1, 2, 3, 4, 5 elements, that does not necessarily mean that Hart also believes or necessarily believes in all the elements which Austin has propounded. So these are basically three fundamental aspects which I wanted to mention in today's lecture. The first was to cover different approaches to interaction between law and morality. The second was that how critique and construction go hand in hand. And the third was that how we should be cautious while labeling a particular legal theorist as a positivist scholar or a natural law scholar. These are the 3 lessons from today's class, and that is it for today. Maybe we meet tomorrow again. We have a class tomorrow, it seems. And we will move ahead with our paper, and we'll pick up the second section of the paper. So I mean, if possible, try to read the second section of the paper, and then we will have a discussion on it. Thank you so much. Anumeha, Ruchita, is it fine or?
Yes, I think we can conclude if there are no questions and comments.
Yeah, fine. If there are any, yeah, we can talk. Ruchita, you want to say something?
Yeah, no. We can conclude, yes.
Yeah, fine then. Now, we fundamentally agree with all these points, and thank you so much for actually putting that point in public domain. And what we have decided to do is that we will follow the case material the way it is provided by the Delhi University. So, for example, if there are certain writings which are mentioned in the case material, fundamentally we will use those. We would use those writings to explain other related writings. Another point which was raised in the last lecture. Now, in so doing, for today, what we have proposed, and this is something which we are going to continue for the next 2 lectures as well, that we will pick up Star's writing, which is already part of or which has already been sent to your Google Classroom. It is uploaded there by Anumeha. Now, Star fundamentally talks about Hart's idea of law. And
दोस्तों, ब्राज ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें। थैंक्स फॉर वॉचिंग।